Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukra, Jurisprudence class. Friends, in this video, we are going to discuss the topic of binding authority of legal theories, binding authority of the legislation, binding authority of the precedent, binding authority of the customary law. So at the outset, let us start with the binding authority of the legislation. So here, please remember, this is jurisprudence class. The Roman jurist Ulpian, he defined jurisprudence as the observation of the things from human perception and a knowledge of the just and unjust, knowledge of law, which is just and which is unjust. Right. So already I told you the theories like legislation. Then legislation can be made by three agencies. Law can be made by three agencies. What are they? The first one, legislatures, or the people who are superior. That means the legislators like members of parliament, like members of legislative assembly. So they can make the law. That's why it is called a statute. Statutory law, 100% you have to obey that. So legislation is made by, so a formal act of legislation made by the legislators in a written form, it is called as a statute. So please remember, the legislature has got the power to amend the law. They have got the power to repeal the law. They have got the power to pass the law. So first point is to pass the law. So please remember. So on which topics they can make the statutes. This is written in Schedule 7 of the Constitution of India. Schedule 7 contains three lists, That is number 1, union list. That means the list which are supervised by, which are governed by the central government, the topics. So they are 47 items. 47 items. So are union list. Second one is state list. That is 67 items. And certain items belong to both state and center. It's combined list. So therefore it is called as concurrent list. The concurrent list is about 97 items. So the union can make law, statute on the union subject as well as the concurrent subject. The state, they can make law on the state subject as well as the concurrent list. So if any actual confusion is there, if any controversy is there, please remember, if any controversy between the law made by the state and law made by the union, definitely the law made by the union, they will definitely withstand and the state cannot frustrate the same. So this is what is called subordination. Of course, when you come to the different types of law, please remember, supreme legislation, subordinate legislation, and delegatedly. Sometimes the law will be delegated to the collectors and others. Yes, collector is competent to give mining licenses in Chemakurti like that. And delegated legislation, the municipality, they can make their own law. Like that, these different types of legislations are there. So what you have to know is, please remember, the legislators are competent to make the law and they are competent to amend the law also. So I will give you a case law, important case law. Hamdard Dawakhana, please remember, Hamdard Dawakhana versus Union of India, 1965. So here, the law made by the legislature, this is 100% accepted. So Hamdard Dawakhana is a very popular company which was preparing the sharbat called as Roo Afza. Roo Afza was a popular sharbat, of course. Young people, you may not be knowing, but in our younger days, it was a very popular sharbat made of fruit juice. So, basing on the powers given under Section 3 of the Essential Commodities Act 1955, the Union has imposed an order that The union has ordered that the fruit pulp or the pulp should be 25%. Should be 25%. So previously, this is sharbat. They used to mix some essence and other things. So they did not care. Ultimately, they have gone to the court stating that actually the fruit pulp order was given in the year 1965. So this fruit pulp order was given in 1965. We have started manufacturing from 1950 itself. So therefore, this is in derogation of the EC Act. So this cannot withstand. This law we are not going to abide like that. They have gone to the court. Of course, straight away they will not say like that, but it is against to the principles of natural justice or things like that. So now a clash has come between the EC Act as well as the fruit and pulp order. So Supreme Court has interpreted the same in ejus rem generis, that means of the same order. Supreme Court stated that definitely for the health of the people, the fruit juice should contain, the pulp should be 25%, there is no other go. Yes, the government has got the authority to make the law. Then what about the manufactured juice, manufactured sharbat? Supreme Court has given leverage. Okay, you can dispose the same, but from later, from that particular date, you have to prepare the juice only containing 25%. So this is an important judgment. So this is the importance of the legislation. So legislation, they make the law, they can repeal the law, or they can pass the law, they can amend the law also. This is important, which you have to learn. So please remember, there are already I told you supreme legislation. Supreme legislation proceeds from sovereign power. It can't be repealed, it can't be annulled, or it can't be controlled. Whereas subordinate, like municipal authorities, they can make law, bylaws law. So this is subordinate legislation. So please remember. So we'll discuss precedent in the next step. Already 7 minutes are over. So anyway, so with this, legislation is having binding authority. If you remember this much, it's all. Thank you.